Every week, someone on Reddit says the same thing. I thought I had 60 days, but I overstayed without realizing it. To break down the real grace period rules and the traps people fall into and how to avoid overstaying without knowing it. So, friends, do stay with us. We're going to discuss on this very important topic, which you can see on the screen already. Are you using your grace period correctly? Avoid overstays. And with that, welcome to Immigration Talk Show. I'm Nipasa. I'm going to be your host for today's session. And we're going to have our guest join us very soon. But for now, this very important disclaimer to keep in mind throughout this whole session. And that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So I hope you're ready. And let me tell you that we are streaming live right now on YouTube, LinkedIn, and Facebook. So feel free to join us in these platforms and also on Twitter, that is X. And you can comment wherever you're watching or dial the number which you can see on the screen to take part in today's discussion, maybe to ask some questions that you have. And the number is 425-436-6335. Also, don't forget to support us by subscribing to our channel. Our handle is at Immigration Talk Show. You can also ring that bell so that whenever we have discussions like these, you're notified. And best thing is you can share this link also with your friends, ask them to join us and enjoy the session with us. And now, please help me welcome our guest for today, none other than Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. Hi, Chand. Always good to have you. Thank you for joining us.
Hello, Nipasa, and hello, everybody. Yeah, thanks for having me on this show today. And hopefully, we will have a very, very productive session. Especially, we have people with various non-immigrant visas, H1s, F1s, L1, various other visas. And the most important thing is you cannot overstay in US. Everybody, whoever is a legal non-immigrant in US, they have to follow the rules of their visa, whatever is their particular visa. And a part of the requirement is you can stay in the country only as long as you're allowed, and everybody has a requirement. If somebody's on F1, they have certain requirement how long they can stay in the country. If somebody's on H1, they have a specific requirement how long they can stay in the country to avoid any future issues. So I think hopefully we will discuss various issues with various the more popular visa classes, and the goal is to educate everybody on how long they can stay in the country and what they have to do before their status expires, and ensure compliance with US regulations.
Absolutely. I'm excited for today's session, friends. And I do have some questions, Chand, which I will move right into very quickly. But also overstaying. I mean, when people come into the US, they already know how long they can stay, how much buffer time they have before they really have to, just in case they get out of status, and how fast they have to move out of the country. But yet, I mean, some do it knowingly, unknowingly, accidentally. I do not know. But today we're going to
Yes.
discuss all of that. And yes, friends, you can also check out Attorney Chand Parvathaneni. You can check out the link which you can see on the screen and go check him out. So, Chand, I think I'll go right into the questions. And this first one is, how do so many people assume that they still have 60 days left, when their I-94 has already expired and their grace period is actually zero?
Sure. So when we're talking about the 60-day grace period, typically it is for a lot of work visas, especially the H1B. So the general rule that a lot of people think is whenever they're out of a job, they automatically have 60 days left. And this rule comes with a lot of restrictions. And what we are seeing is we are seeing a lot of NTAs, notice to appears, being issued for a lot of people, because not everybody has the 60-day grace period. And there are certain limitations on the 60-day grace period, especially when it comes to H1B. And I think you're right. A lot of people assume that when they're on H1B, they just lose their job. They automatically have 60-day grace period. That is not always true. So the first and the foremost thing, like you said, is the I-94. Everyone should always check their I-94. So I-94 is the drop dead date on when somebody has to leave the country. So nobody can exceed their I-94 date. And what that means is if somebody just lost their job, usually the general consensus is yes, somebody has 60 days of grace period, but there is a small caveat. And the first and the foremost thing is I-94. Everybody has to always check their I-94. The 60-day grace period is applicable only if the I-94 is still valid. So if somebody's I-94 is expiring, say after 30 days they lost their job, they only will have 30-day grace period, not really 60 days. So you cannot exceed your I-94 end date. So you always have to look at what your I-94 says, and everybody should know how to check their I-94, because there is a lot of confusion on I-94. You get an I-94 when CBP, when you come into the country, whenever the Customs and Border Patrol inspects you, they give you a I-94, and you can download that I-94 online. You can go to the CBP website, you can look at your I-94, and there is that I-94. And then when people are doing H-1B transfer or H-1B extension and so H-1B amendment and so on, USCIS in their approval copy will also issue an I-94, and that I-94 does not get updated on the CBP website. So everybody should know that there is a USCIS I-94 in some cases, and then you have the CBP I-94. And there is something called last action rule. And what the last action rule says is, when you have two different agencies give you a 994, maybe in this case CBP and USCIS, the last action rule always says that whatever is the most recent action, the last action, you have to take a look at that I-94, and that I-94 is the I-94 that you have to follow. And unfortunately, what we are seeing is a lot of people sometimes just look at their CBP I-94, and if they have another action, a last action from a recent I-797 approval, they sometimes don't see that I-94 or vice versa. So, and they get confused. So everyone should always know that you should be looking at the most recent I-94, whether it is CBP or whether it is USCIS. The most recent I-94 is what dictates your status in the country. And do not ever miss that part, because people forget to check the I-94. So always check your CBP I-94, always check your USCIS, maybe in the approval copy, the 797 I-94. Always see what is the most recent one and use that as your I-94 end date. If in doubt, always check with your employer or with your attorney, because you cannot miss that. If you ever even accidentally miss that I-94, you overstay your I-94, you could have a bar in the future. You cross 180 days, you'll have a mandatory bar. So the bottom line is the 60-day grace period is only valid if your I-94 is still valid.
There you go, friends. I think that was a very clear explanation. Thank you so much, Chand, for that great introduction to this very important document, the I-94, and to know how long you have your stay here in the US. So thank you for that. And hello to Sid Mohan. Welcome back once again. He's one of our very regular viewers. So happy to have you. And we are going to address all of your questions. Friends, just keep commenting wherever you're watching. And yes, thank you. But I mean, with so many questions, I mean, I'll just say that's it. Maybe we'll not be able to take up all of them. And best thing is, if you can join us on call, you can just ask all of your questions, get your answers, and I think that way it's easier also. But thank you nonetheless. Good to see you. And also, Chand, we see that there are many factors, and it makes the grace period difficult for many immigrants to track accurately. So, this leads to unintentional status violations. If you can tell us about some of these factors, it'll be great.
Sure. I'll talk about one issue that I'm seeing a lot nowadays and causing a lot of issues. And the main issue is, so what happens is people get an H-1B approval. And say they get an approval for 3 years. They look at their H-1B approval, the approval copy from USCIS. They see their I-94 date on their H-1B approval. They just assume that they're good to stay in the country for the next 3 years. The problem is, after they get their approval, they travel out of the country. They go out of the country and they come back. Travel will reset your I-94 end date. The reason is, whenever you travel out of the country, you come back, CBP will always issue you a new I-94 that you can download on the website. They do not put it on your passport. They ask you to download it on the website, the CBP website. And people just assume that because they have their H-1B approval for 3 years, they don't have to check their CBP approval. And what we are seeing is CBP sometimes accidentally makes a mistake, or sometimes what they do is they shorten the I-94 to the date matching on their passport, the passport expiration date. And unknowingly, the I-94s get reduced because of their travel. So whenever people are traveling out of the country and coming back, the unintentional violation that we are seeing is people forget to check their I-94. And now CBP is giving them a different, a reduced I-94, and people are just assuming that their H-1B approval is the valid one. And this, the reason CBP shortens the I-94 date is typically because the passport is expiring. So when the passport expires, CBP will always reduce the I-94 end date, or sometimes maybe it's a mistake. And what happens is people don't get any kind of a notification. And whenever the times comes for extension filing or transfer filing, in our law firm, a lot of times we are looking at the I-94 issued by the CBP, we are looking at the I-94 issued by USCIS. And because of this travel, the I-94 got reset. So now we have to go back and tell that somebody has unintentionally violated their status. And people are stressed out. We are having to go back to USCIS, explain what has happened, and USCIS may or may not approve it. And this kind of a miscalculation will lead to overstay. So the short message for everybody is, anytime you travel out of the country, that travel will reset your I-94. So whenever you're traveling out of the country, always download your I-94 immediately and make sure everything is right. If not, if your I-94 got reduced, at least you know that you have to act and apply for an extension before your CBP I-94 expires.
That's a great tip, Chand. Thank you so much for that. And I think most people didn't know, or maybe this is much of a clear idea. So thank you so much. I think you can give some of the to-do list, especially when you're traveling out of the US for immigrants out there. So maybe three of them would be great.
Sure. The first thing I think everybody should do is take a look at your passports. If your passport is expiring very soon, it is a very good idea, probably a mandatory idea, that you get your passports renewed. Reason is, if your passport is expiring in say 1 year or 2 years, but you have an approval for 3 years, what CBP will do is they will reduce the I-94 to your passport expiration date. So first and foremost thing, look at your passport. If you're traveling out of the country, if your passport is expiring in the next 1 year or soon, a very good idea to get your passport renewed. Very important. That's number one. Number two, immediately download your CBP I-94 as soon as you come into the country, the very next day. If there is a mistake, you immediately go to the CBP office. They will correct it. You wait for too long, CBP will say it is your responsibility. So download your I-94, ensure there are no mistakes. The third thing is, it's a good idea to pass on that I-94 to your employer, because your employer can look at their USCIS approval copy, look at your I-94, make sure everything is proper. If not, they at least will be aware that they have to file for an extension in case CBP reduced your I-94. So these three things, I think if you do, you'll make sure that you're not causing yourself unnecessary panic if down the line you find out that CBP has reduced your I-94.
Those were awesome, Chand. Thank you so much for that. And folks, I hope you're enjoying this very informative session. Please do not forget to subscribe to our channel. We are on YouTube and our handle is at Immigration Talk Show. You can also check us out on LinkedIn, Facebook, X, on Instagram as well, and stay in touch with us. And another thing is that, you can always hit that bell icon so that whenever we have discussions like these, you're notified, and comment wherever you're watching. We would love to know where are you joining us from, and if you have had any doubts like these before, or you want to know what you should do next, just comment and make sure that you stay on the topic so that we can take your questions up in this session itself. All right, good to see you, Samantha. Let's take up Samantha's question. I'm currently on F1 OPT and my employment just ended. If I'm actively interviewing and applying for H1B sponsorship, can I legally stay in the US during the grace period? And what are my options if I don't secure a job in time?
So when somebody is on F1, again, F1 has again a grace period. So once you're done with your F1 program, again, there is a grace period that you can stay back in the country. And the good thing about F1 program, at least as of today, is if you look at your I-94, it will say D by S. Normally for a H1B or some other statuses, the I-94 will have a specific end date. But for students, what happens is they have something called D by S. So duration of stay. And what that mean, duration of status, what that means is, as long as your F1 program is continuing, or as long as your OPT is valid, you are good to stay in the country. And once that has ended, you still have a grace period. And the rule for F1 is, during your grace period, say your F1 period ended, your OPT ended, you're staying in the country within your legally allowed grace period. During that time, you are allowed to find, I mean, if you find a job, the company can file a change of status and you are allowed to stay back in the country. And this scenario comes very, very often in the month of April, because usually what happens is, in the month of March, we have the H1B lottery or the H1B registration process. And in April, you have to do the filing. So the rule is, even say your OPT expired, say in the month of March or say in the month of February, and you got selected in the lottery, during your grace period, if your company can file or is allowed to file a H1B petition for you within your grace period, you can stay back in the country. So the bottom line is, yes, if you are on F1 program and you finished your F1 program, you finished your OPT, but you're still within the grace period and you're in the country legally because you do have that valid grace period, a change of status petition can be filed. The problem is if you don't secure a job in time. So the rule is, within your grace period, you are legally allowed to change your status to any other legal status, as long as it is a non-frivolous application. So if you have, for example, like a option like a H4 or some other visa classification option that is available for you, you are allowed to change status. I mean, if you get a job, you're qualified for H1B, that is one option. But if not, if you have any other legal option, as long as it's a non-frivolous application, you are allowed to change status to a different status.
All right. Well, there you go, Samantha. Thank you so much for your question, and I hope you are happy with the answer. Thank you, Chance, for taking that up. Well, Sid Mohan, I would really request you to stay in topic. We may not be able to take up all of your questions, but we have Bhargav. Hi, Bhargav. Thank you so much for joining us. He says, "Hi, Chand. If I lose my H1B job unexpectedly, does the 60-day grace period start from the termination date or the last paycheck date? And how can I prove this timeline if USCIS ever questions it?"
And again, this is also very, very important, because a lot of companies pay severance, or maybe they have some back pay to pay, and they pay. And the USCIS rule is very, very, very clear. It is not about the pay stub. It is not the date your last pay stub came to you. It is the date you were terminated. The last date of your employment is the date you have to actually start counting the 60-day grace period. How would USCIS know about it? They can always come back and ask your employer, or your employer might, because every employer for H1B, they have to revoke the H1B if you're not employed, which means they have a legal burden to go back to USCIS and report that your employment has terminated. So again, obviously, they have to let USCIS know the last date of employment, not the last date of your paycheck. Not only that, in the future, you have to get an experience letter, you have to get a relieving letter, because you need to probably use it for your I-140 or your DS-160 and so on. So it is always the last date of employment. And normally, what people always do is, they go to their employer, they always ask for a relieving letter or their experience letter. That will also clearly clarify the last date of work. And that is something what you have to use to count your 60-day grace period. Because sometimes what happens is, just because you have a pay stub, you go and apply, and then USCIS down the line finds out that your employer, your past employer, they sent you a revocation note. They sent a revocation note request to USCIS, notifying them that your employment has terminated. And then if you cross your grace period, you are at risk for getting an NTA, notice to appear, because this is what has happened to a lot of people. And if you get an NTA, unless you have proof clearly proving your last date of employment, you will not be able to prove it. So the bottom line is, don't look only at your pay stub. Look at the actual termination date and use that to count your 60-day grace period.
Thank you so much, Chand, and I hope that was very helpful for Bhargav as well. Bhargav and Samantha, and all you folks watching us right now, please don't forget to subscribe to our channel. Our handle is at Immigration Talk Show, and ring that bell so that you can get notifications whenever we have important updates for you. And also, yes, we are live on YouTube, LinkedIn, Facebook. You can also check us out on X and on Instagram. And for now, Chand, I had another question. If you can tell us, why does USCIS send It doesn't actually send any alert, when a grace period begins, even though overstays are punished, as if everyone knows the exact, start time, which is so important. We have no notifications. So why is it like that?
Sure. So so what again USCIS or in general the legal system, the way it works is ignorance of law is not a defense. And what that means is every person, like every in this case every non-immigrant, they have a full responsibility to know their the rules and regulations. So that is how the legal system is generally designed, because you cannot say I don't know the law or I don't know something. That is not really a defense at all. So everybody has their own responsibility to know the laws of the land. And not only that, that's one part. The other big part is USCIS. There is no way of USCIS knowing when somebody's employment ended, because theoretically the grace period starts when somebody's employment terminates. So USCIS will not always know immediately when somebody's employment ended, because some employers, they immediately notify USCIS that employment has ended, and some employers, what they do is they take their time. They take a few days to let USCIS know that the employment has been terminated. So for that reason, in general, there is no way of USCIS immediately knowing when somebody's employment has ended, and the grace period actually starts the day employment stops. So since there is no automatic mechanism to receive this kind of an this message from the HRs when somebody's employment ended, USCIS is not even in a position to send out these alerts. And even if they're in a position to send out an alert, the way things work is somebody, whoever is the person involved, they have complete responsibility to know their grace periods and know their timelines. And this is another reason why everybody should be aware of these rules and regulations and immediately start counting their grace period and make sure they don't violate the grace periods. Because if you violate the grace period, you get lucky that one particular time down the line you might have a site visit, an FDNS site visit, or you might go for a visa stamping. At some point of time the system will catch it, and when they catch it, they could always go back and depending on the situation, could penalize overstays depending on how long the overstay occurred. So for this reason, always the simple rule is, if your employer told you that your job has been terminated, you have that burden to start counting the day of grace period right away. But again, if sometimes the employers don't follow the rules, which is the employers don't even notify the employees, which means the employees don't even know when their grace period starts. So if the employer is not paying you, but the employer does not even tell you that your job is terminated, in that case Department of Labor will always assist you in any wage violation. USCIS will assist you in a wage violation. So if the employer has not even told you about your termination, there is no way you will find out about termination. But if employer followed the rules appropriately, terminated has done a proper termination of your job, notified you, then the burden falls on everybody to start counting their grace period.
That's right. And I think you have to take it as a very, very important thing, friends out there, to keep note of your grace period just so that you don't fall into trouble. And I would say, always consult with an immigration attorney, with whatever your case, your status is, so that you are on the right path and you're sure and can live more confidently here in the US. And why not check out Attorney Chand Parvathaneni also from SPB Law Firm, Dallas, Texas. You can check him out and check this link, which you can see on the screen. And Sid, I can take up one of Sid's question, which is about his visit. H1B approved in 2023 and renewal in September 2026. Planning to have first time stamping in India in March 26. Given this, how long will the visa be valid for? Will I have to get a new stamp after renewal?
So theoretically, looks like if he's going in March, his approval is only valid till September. So that's about 6 months ahead of time. So the visa will definitely be valid only till September 2026. And so the rule is, like, typically when you're close to getting an extension filed, you should always get an extension filed. And the rule is you can only file for an H1B extension only when you are within the 6 months mark. So if your current H1B is expiring, say September 30th, the earliest your company can even file for an extension is March 30th, because you can only file for an extension when you are within that 180-day timeline. So if you're going in, so say early March, your company might not even be in a position to even file for an extension. So if you go with that particular approval, you'll only get stamping until September. Uh, so usually what people do is they wait until their extension is filed, they wait for that approval and then go for stamping, because then you can take advantage of that extension approval and then maybe get an approval for a longer period of time. So, but again, if you're going in March before your extension is filed, you can only get until September. And coming back, once you get a visa, even if it is only valid till September, that should not cause an issue. But the challenge is the visa is only valid till September, which means again in the future you have to go for stamping once again.
Right. Right. Thank you so much. And Sid, I hope that you got your answer. And another thing you wanted to know is if the H-1B wage increase rule comes to play, will it impact existing H-1B workers at the time of H-1B renewal next year? Or will a new wage have to be forced in on the LCA?
So the way it works is, at the time of any H1B filing, we have to look at what the wages are, and those rules are applicable. For example, in this case, Sid's case, in 2023, when the LCA was filed, the wages were completely different, and now the wages have already increased. So the wages get updated every July. So every July, in FLC Data Center, the website that all of us use, the wages will get updated every July. It's a thing that happens every year, and the reason is the wages have to be matching whatever is the industry standard. If not, it will impact the local labor market. It will impact the US worker. So for that reason, irrespective of any rule changes, every year in July the wages get updated. So in Sid's case, even as of today, if you look at the LCA wage levels, the wages have already increased from what it was in 2023. So in the future, whenever it is time for the renewal, on that particular day, we have to look at whatever the wages are. And right now, already there is a process in place to review and update the wages. So come March, if the wages are updated and new rules come into picture, whatever are the rules at that point of time, at the time of filing the LCA, we have to use those wages. So again, as of today, the wages were updated this July, 2025 July. And again, if no rules change, irrespective of that, next July, 2026 July, the wages will anyway get updated. That being said, there is a rule making process already that has started. So the wages increase, and there is a final rule published in the Federal Registrar. We might even see wages get updated before that. But my view is, I think the wages definitely will get updated in July. Before that, I'm not sure yet, because that process is a time consuming process, the whole rulemaking process. So before March, I don't know whether the rules will get updated, but definitely by July, I think we will definitely see an update in the wages.
Right. Absolutely. Ever evolving landscape, I would say, our US immigration is. So it's always important to keep yourself updated. And for that, please do not forget to subscribe to our channel because we come up with the latest updates. And with webinars like these, I think this is like, a bonus for you because who would give you such good and important information? So do not forget to support us as well. Subscribe to our channel and ring that bell so that you are notified whenever we have very important discussions like these. And Chand, I don't know why, but how do so many overstays happen? Because people rely on HR timelines instead of checking their own I-94, is it?
So I think the reason a lot of overstays happen, I think it's also the question that you just asked a few minutes back. Do we count the grace period from the last date of employment, or from the date their paycheck ends? A lot of people get confused, and a lot of people unfortunately just assume that because they have a paycheck, they can just start counting the grace period whenever the after the last day on the pay statement, because they feel that USCIS will just look at their pay statement and then count the grace period from that date. So that is the reason where I saw a lot of people make a mistake. That is one case. And a lot of people also don't look at their I-94. That's also another reason why I've seen a lot of people make a mistake. Because what happens is, when you get a H1B, you get a H1B for 3 years. And some companies, after the end of 3 years, they will not even file for an extension. So people just assume that, hey, my employment with this employer has ended, my 3-year employment. Now I can find a new employer. And they just don't check their I-94, because when their initial H1B expires, the I-94 also expires. So if that company is not filing for an extension, pretty much the I-94 is expired. So now you don't really have a grace period because this company has not filed an extension. And that's also another place where I saw people make a mistake because they feel that they have 60 more days to find a new employer. No, the 60-day grace period is not available if the first company has not filed for an extension. So that's also another place where I see a problem. Another place where I see a problem is, and this is a common question, how many times can you use this grace period? Can I keep changing employers and each time use the 60-day grace period or not? So there is one small caveat with that. So whenever somebody changes their employer and a new employer files for a H1B, people start working on a receipt, which is legal. So some new employer files a H1B and they can work on the receipt. But when it comes to using the grace period, the 60-day grace period is applicable each time they get an approval. So with the employer one, they get an approval, they get 60-day grace period. And now say they change their employer, they go to the second employer, employer two, but somebody is working on the receipt. They don't have an approval with that employer. And now if their job terminates, if they've used the grace period in the previous approval period, the grace period is not applicable. The grace period is applicable with the second employer only if they have an approval with the second employer. But if they're working on a receipt, they might not have a grace period. So the 60-day grace period is for each approval copy. So for each time they have an approval, they have a 60-day grace period. So if they're working on a receipt with the next employer, if that case gets approved, yes, they have the 60-day grace period. If not, they might not have the 60-day grace period. So there are some fine nuances that people have to see when they're counting the 60 days. So the 60-day grace period is again discretionary, and there are few nuances. So everybody should be aware of these nuances and make sure they know the correct calculations. And this is very important to ensure that they're not accidentally violating their grace period and overstaying in this country.
So true, so true. Thank you so much, Chand, for that. And when you actually look at the situation, why do so many individuals discover potential overstay issues? Whether it's through informal online forums instead of receiving clear guidance from official sources.
Right. And I think again, the main thing is, again, I think one of the suggestions that you suggested in the call in this session earlier, which is why doesn't USCIS email and warn people? And since like nobody gets a personalized warning, I think a lot of times people don't even know about it until they're like on some social media or Reddit, and they find a scenario that matches their scenario and realize that they made a mistake. I think the grace periods have like a lot of nuances, and again the grace periods are discretionary. And what's happening is because sometimes everybody's situation is not same as somebody else's situation, they kind of incorrectly calculate this grace period, and now USCIS is not having a way of issuing a personalized warning or an email. People sometimes miss it. And another thing is going to a lawyer. Going to a lawyer is not practical for each and every small thing. There's like not an easy way where they can approach their lawyers. Normally, if they have a HR, they can go talk to their HR. But once people lose their job, they go through a H1B termination. They sometimes don't have full access to their HRs, and going to an immigration lawyer each and every time for small things, because sometimes it is expensive. They don't use lawyers, and sometimes they realize when they're reading somebody else's situation on Reddit, they realize that they made a mess up. Uh, so I think what people should be doing is, I think, be aware of the regulations, and sessions like this, I think, are ways where sometimes people get educated. And the thing is, the 60-day grace period has so many intricacies, so many exceptions, and that is something what people should be aware. Okay, things what I would say is, everybody should know how to look at their I-94. When you have multiple I-94s, you should know which is the valid I-94 in your case, number one. Number two, people should know when their grace period exactly starts. Is it their last date of paycheck or last date of work? That is very important. And also, when people are using the 60-day grace period multiple times, okay, when they change employers, you should know the rules associated with it, because there is a rule that says the 60-day grace period is for each approval, not each time they change their job. So there are small variances of this rule. So, and because what has been happening is, if people don't follow the rules, we are seeing people being issued NTAs, notice to appear. Notice to appear means, uh, the government wants to deport you because you have not followed the rules. So now you have to appear in front of an immigration judge and answer to the immigration judge. So to avoid all of these things, it is very important that you go through sessions like this, or educate yourself, and don't even accidentally overstay.
Absolutely. Overstaying is not legal, and keep that in mind. Thank you so much, Chand, for taking up that question, and there are many more things I wanted to know, but we will quickly take up one more question from the audience, and this is Venkat. Hi, Venkat. Thank you so much for joining us here on YouTube. And he's asking if I'm planning a change of status, say F1 to H1B or H1B to H4, how early should I file to ensure I don't fall into a grace period gap? And what happens if USCIS delays the decision?
So again, so everybody should plan at least a little ahead of. So whenever you want to do a change of status, and you are on the grace period, don't wait until it is the very last minute. Do it at least a little ahead of time. And the good thing is, if it is H1B, you're filing a H1B during your grace period, or you're getting a filing done to H4 during the grace period. A lot of times what we suggest is, if you do a paper filing, something goes wrong, maybe with the FedEx, or maybe with your payment check or payment credit card or something. By the time you realize, by the time USCIS kicks the case back and says they're rejecting the case because there is some issue, it is too late. So the easiest way to ensure that you're not uh, overstaying is utilize the online filing. USCIS now has ways to do an online filing. They have online filing for H1B, they have online filing for H4 if it is done separately. So if at all you're in a grace period, avoid paper filing. Make sure a little ahead of time you do e-filing. The reason is, when you do an e-filing, you get a receipt. You are avoiding accidental mistakes like FedEx mess up, or payment card mess up, or something that is unexpected. So again, do the filings well ahead of the deadline. When I say well ahead, at least I would say at least 3 to 4 days ahead of the deadline if you're doing e-filing, because when you're doing e-filing, you get the receipt the very same day. So you know that at least you have put your case in front of USCIS well ahead of the grace period. But if you're doing a paper filing, I would say you should do it at least 2 weeks ahead of time. Otherwise, there are too many chances of surprises. Uh, and then again, one thing everybody should ensure is that change of status filing should be non-frivolous. Because if you're filing for if your company is filing for a H1B without a bona fide assignment, that is something what USCIS will come back and deny, and you are going to be in trouble. So always make sure that the filing is non-frivolous, and you do it at least a little ahead of the deadline. And you don't have to do it way ahead of the deadline, because nowadays with the advantage of e-filing, you get the receipt the very same day. So at least if it is like 2-3 days ahead of the deadline, you're good. Only thing is, be very careful in the way you calculate your grace period, because if you make a mistake in the way you calculate your grace period, tomorrow you will be in trouble. If you cross your grace period, USCIS will deny that change of status request.
There you go, Venkat. Thank you so much, Chand, for taking that up. And I hope folks out there, you're enjoying this session. It's very educative, informative. Do not forget to subscribe to our channel, please. Our handle is at Immigration Talk Show. We are on YouTube, LinkedIn, Facebook, and on X as well, on Instagram as well. So check us out, and do stay in touch with us. So, talking about the 60 days and the 120 days, why shouldn't the US consider extending the 60 days grace period to 120 days? Because if you look at the hiring side and onboarding, it takes months, right, Chan?
Right. And again, in terms of the practical aspect of increasing the grace period, at this point of time, I don't think there are any chances, because there is no bill or any proposal, like a regulatory proposal, to extend the grace period at this point of time. And that being said, I think in 2025 we did see a lot of tech layoffs. We did see a lot of hiring freezes, and a lot of anti-immigration rhetoric also going on. And I think, again, in general, the H1B program, it's designed not to impact the local labor market. And when the local labor market is very strong, and there is like a shortage that is justifiable, I think usually uh, 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 things of this sort are possible, like extending the grace period and all these kind of things. Proposals are possible. But now, with a lot of tech layoffs that we heard in this year, and with the H1B program majorly used for the tech industry, I think increasing the grace period at this point of time probably, I think, might not be a practical scenario that we could see in the next coming days. And not only that, I think with the AI, with a lot of focus on AI, and a lot of people are complaining that AI is causing all these kind of tech layoffs. And with that kind of a scenario, I think it is a little bit hard. But I think from your question, I think whatever you said is like clearly justifiable, because somebody is working in this country for such a long time, has paid taxes, and has contributed to the local economy, and has assets here, like maybe they have a house and car, because people have invested in the local economy. So again, 60 days is definitely a very, very tricky time. I mean, like if somebody is in a month like November, like holiday season has started, so November, December, in the tech industry, it is very rare that they do hiring in the last quarter, because things are so slow during the holiday season. So 60-day grace period is like really challenging. And what it is doing is, it is causing a lot of uh, stress to people who have invested a lot in US, because not only they're contributing to the US local economy, they have assets, they have kids in school, because when people are on H1B, they have families here, they have their kids in school. So it is definitely, it is not right that people have such a short notice. 60 days is really short, especially in a time like holiday season, or when there are a lot of tech layoffs. So definitely, I think it's a good idea if the government can consider increasing the time period. But a lot would depend on the local economic impact. So I think it is definitely, I mean, I did see talk of uh, calls for the government to increase the grace period. And again, honestly, it would help a lot of people, because increasing the grace period will at least help alleviate fears. Because when people fear that the grace period is too short, what will happen is people will not invest in the local economy, they will not invest in buying a house, they will not invest in buying assets in US. So in the interest of the local economies, definitely increasing the grace period will uh, help contribute towards the local economy, because now people will be more motivated to buy assets when they know that the grace period is reasonable enough. But at this point of time, 60 days probably is not a great amount of time to find a new job.
That's right. That's right. Chan, thank you so much for taking that up. And yes, we have Satish also who has joined us, and I would like to address his questions. He says, I moved from F1 to H1B status this year. My H1B was approved about 10 days ago, but my employer is still not sharing the receipt notice or the approval notice or the e notice. Whenever I ask, they say the attorney is not sharing it with them. Is this normal for a change of status case? When should the employer or attorney normally receive the e approval notice? Also, is it legal for an employer to withhold these documents from the employer?
So the H1B was approved 10 days ago. So the company knows the case got approved, which means the company knows the receipt number. And again, if it is e-filing, because there are two ways people can do a H1B. One, e-filing, which is probably the way your attorney has done it, because most of the time nowadays, like everybody is doing an e-filing for H1B. So if it is done as an e-filing, what will happen is the employer will have their own portal account, own my USCIS account. So they should be able to just log into their my USCIS portal and download the receipt copy, download the approval copy immediately. Okay, so that is one part. And the attorney has a burden to share it with the employer right away. So if the employer is not being shared the copy by the attorney, the employer, I don't think, will keep quiet. They'll immediately talk to the attorney. And attorney has a legal burden, because they're licensed attorneys. Employer, it has to be shared with the employer, because employer is the client, they are the petitioner. So the company in this case definitely should have access to that H1B, and they definitely can go to the portal and even download the receipt copy, download the approval copy right away. And then on top of it, the case got approved in 10 days. More than likely, it is a premium processing case. That also means that they get a email approval copy, is the approval notification in the email. So the email should be there. So from a high level, I think that approval copy, again, I think the employer is probably saying something that doesn't sound logical to me. When the employer says that they don't have access to that approval copy, it doesn't sound logical to me. And then from the burden of the employer, the employer definitely has to share the copy of the LCA right away, because that is not even something that employer has a choice. The LCA has to be given to the employee, because by law, every employee should know what's in the LCA, how much they're supposed to get paid. It is very, very important. And talk to your employer and ask him nicely, because if the employer does not give it to you, there is a recourse. You can go to DOL, because that's a violation if the LCA is not being shared with you. You can go to USCIS and let USCIS know. But the problem is, if you contact USCIS, USCIS will not immediately give you the approval copy. They will say that you have to talk to your petitioner, who's the petitioner, to get a copy. But if you want to get a copy from USCIS, the way you do is, there is something called FOIA, Freedom of Information Act. So you have to initiate a Freedom of Information Act request to USCIS, and USCIS will not immediately give it to you the next day or the very same day. But they will give it to you. So if you want to get it through USCIS, you have to file FOIA, Freedom of Information Act request, and get it through USCIS. But as far as the employer is concerned, tomorrow, this is what I see. If the employer got an approval and this is a change of status request, they are liable to pay you from the date of this case getting approved. So tomorrow, if the employer is saying they don't have the approval copy, they are putting you on the bench. It is technically the bench, because you are ready to work, and employer is not hiring you. So employer, irrespective of whether they shared the LCA, the approval copy or not, to me, if they're not paying you, that is benching. And USCIS and DOL will argue that that employer has to pay you. And the bottom line is, again, check back with your employer, ask him what is going on, and talk to him about downloading it from my USCIS website. Because to me, I mean, they can just log into USCIS, download the receipt copy, download the approval copy, and give it to you. So I don't see why they have a problem with that.
Thank you so much for taking that up. And Satish, I know that was very helpful. So all the best with it. And Chand, there are more questions. And I wanted to ask you, why do these employees often misunderstand, the impact of severance on immigration status, even though it does not really extend or modify the grace period?
Right. So severance pay. So basically, so a lot of companies, what they do is, some companies give severance pay, some companies do not pay severance pay, and sometimes some companies, because of local state laws, they are required to pay severance, and the rules are different in every state. The rules about severance are different, and every employer is different. And some companies, because of goodwill, they pay severance, because some companies are nice, and to safeguard their reputation with their other employees, they pay severance. And again, the way they pay severance varies. Some companies may pay like 1 week, maybe a month, maybe a year, and it depends. And some companies also pay for unused PTO. So maybe whether it is severance, whether it is unused PTO, or whatever reason, maybe it's an agreement that you have, an employment agreement, where the company is required to pay you if they terminate your employment in the middle of your employment. So for various reasons, the severance, what it does is, it extends your pay. At least it will help you to get paid. But when it comes to immigration status, what USCIS wants is, USCIS wants you to follow the requirements of your visa classification. So if you are on H1B, USCIS wants you to work in the country. So they want to make sure you're actually working in the country. So if you're sitting at home and you're getting paid without any reason, that is not enough to safeguard your status. So severance package or a severance pay, yes, it extends your paychecks, but it does not extend your status. So that is something that is very important. So the day your active employment stops, your grace period starts, and people just assume that they're employed because the company is paying them. So for that reason, you have to be cautious. So you have to ensure that your active employment, the day your active employment stops, is the day your grace period starts. If in doubt, always check with your employer and ask them, what is your last day, what is my active date of employment, and if possible, get a relieving letter from them. So that way, that relieving letter from your employer will clearly prove that the last date of employment is whatever is the last date. That employer also confirms. And don't ever use your only date to calculate your grace period. Always look at the end date of your employment, and always take this relieving letters or experience letters from your employer, because tomorrow you have DS 160. Tomorrow, when your new employer is filing the perm, you have to put your employment dates. Tomorrow, when you're filing your 485, you have to put your employment dates. So you cannot have ambiguity of your employment dates, which means if your employer tells you that your employment is getting terminated, get all these documents ready, your experience letter, your relieving letter, and so on. And do not use your paychecks to argue your end date.
Thank you so much, Chance, for taking that up. Very, very helpful. And Satish, whose questions we just took up, he says, thank you so much. So thank you so much also, Satish. I hope you're having a good time. Please don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. And check us out not just on YouTube, but also on LinkedIn, Facebook, X, and on Instagram as well. So, Chand, what key concerns cause immigrants to hesitate before leaving problematic workplaces? Knowing their 60-day grace period would immediately begin.
Sure. I have a lot of, times when people call, they really have a toxic job. They really have something going on, some kind of a harassment at their job, maybe some kind of illegal thing happening at their job. And they want to get out of that job, but they're worried. And a lot of people who are immigrants working on H-1B or other visa, at the end of the day, again, these are real people who have real problems. They're also working. And the thing is, when there is a toxic job, a lot of times people are worried because status is super important. And anytime somebody is a non-immigrant, they have a requirement to maintain status. And what that means is, if somebody is on H-1B, they are required to have employment. So that causes a lot of people from second guessing whether they want to complain if something bad is happening at their job, and so on. And what people should always remember is, there are very, very good whistleblower protections. And what whistleblower protection means is, if something illegal is going on or you raise an important issue, there are strict protections that will prevent the employer from firing you. So, and what that means is, you should get educated. You should probably research a little bit more on your situation, because you might have some protections where you can't be just fired if you report something illegal going on. So the whistleblower protections are legal protections given to both US workers and even non-immigrant worker in US. Everybody has that same level of protection. And what that means is, you don't have to be worried if something wrong is happening. If you're being harassed, you might have some legal protections that or you're being asked to work overtime illegally, you might have some protections. So just because you're non-immigrant doesn't mean that you don't have protections. So when it comes to labor laws, everybody is treated the same. Everybody, whether you're a non-immigrant, whether you are an immigrant, or whether you are a US citizen or a green card holder, the laws are the same. And the reason for that is because they want to protect everybody. They want to protect the workers, they want to protect US workers and everybody involved. And so you don't have to fear losing your H1B eligibility or anything. So always, again, if you are in a position where your job is very toxic or something illegal is happening, you do have protections. So there are a lot of protections that the government has already in place. So you just have to research. But again, you're totally right that a lot of times non-immigrants, when they're on H1B, they feel stifled. They feel that if they complain, they have to worry about their status. But that is the reason why people have to research and see the protections that are available. Things like employer not paying you on time. So all these things are things that are protected. There are laws already to protect both the non-immigrant workers, and not only that, in return, that will also help the US workforce.
Absolutely. Very well put, Chand. Thank you so much for taking that up. And yes, there are more. I have a couple more questions, which will be enough, I think, to wrap up today's session also. And if you can tell us, which option is smarter, leaving the US early and re-entering clean, or staying until the very last day of the grace period?
Again, I think because again, the job market, again, it's different for every technology, because people are working in different technologies. For some jobs, like AI, ML nowadays, it's people are finding jobs pretty quickly. And when it's like some kind of an older technology, sometimes it is challenging to find a job. So I think everybody should basically make sure they always know whatever is the last day. And so if they stay in the country and they find a job, the good thing is, because now in the recent days there is a presidential proclamation about 100K fee. that has made things a little bit more challenging. When somebody is in the country in a legal status, they do not have to pay the company does not have to pay the 100K fee for H1B workers. But if somebody leaves the country, yes, H1B can be filed, but the problem is when somebody's out of the country and the company is filing a H1B under consular processing because somebody's out of the country, what will happen is the 100K fee is required for H1B. And what that means is that will completely decrease the number of openings, number of job offers that they might have if they're out of the country. When they're in the country, people have better options to find a job. And that being said, if you cross 60 days, tomorrow your future H1B applications or future re-entry into the country is jeopardized because you violated your status. So what this means is everybody has to kind of look at things as a whole and make sure you make a smart choice. And what that means is do not exceed your I-94 in the country. Do not exceed your grace period in the country. And based on that situation, if you find a job, it's good. If not, if you're not able to find a job, there are legal ways where you could change your status if you're qualified. So you might look at considering changing your status to a legal status, but you got to do it in the right way before your status expires. And if you cannot do anything, like you don't want to file your change of status or you're not eligible to file for a change of status, then definitely you should depart the country, because you don't overstay. You can always, in the future, you'll always have a way back of legally getting back into the country.
Absolutely. Thank you so much, Chand, for that. And Shravan in LinkedIn says, I have questions. Shravan, I would say, please comment on LinkedIn. We will take up your question. And yeah, meanwhile, Chand, another thing I wanted to ask is how likely is it that accidental overstays, seen all over Reddit, could happen to you too, or, without you even realizing it, for people out there, without them realizing it?
We have cases all the time. I mean, today, right now, after this call, I have another case where this is what happened to this person. He has an H1B approval till March. This company came to us recently thinking that they are ready to file for an extension because his H1B expires in March. And then what I realized is this person went out of the country like a few months back, 6 months back. And then when he came back into the country, because his passport was expiring, his CBP I-94 was given only until last month, October. And because the company was wanting to file for an extension, we just realized today that this guy accidentally overstayed, because both the company and this employee, they were under the impression that their H1B approval is valid till next year. They did not realize that CBP shortened their I-94. And these kind of cases I have all the time. And when we see this case, the employer is stressed out, employee and his entire family is stressed out heavily, because they never intended to overstay. Their intention was never to violate the rules, but now they ended up in a position, a spot where they have overstayed. And there is a way. So what USCIS says is there is a way called NPT, non pro tunc. So if there is a real good reason, extraordinary circumstances, and you prove to USCIS what happened, how quickly you reacted, and so on, USCIS has a discretion. It is not going to get guaranteed approval, but USCIS has a discretion. And they understand people are humans, and they look at intent, whether it is willful, whether it is misrepresentation, whether what happened. But the problem is it is discretionary, and what that means is until this case goes in front of USCIS approves this case, people are heavily stressed out. So we see accidental overstays, and sometimes it is really a genuine problem, a genuine mistake. USCIS understands that people are human, and they have a process in place to look at this case on a case by case basis. Uh, but because there is so much of uncertainty, it causes a problem all the time, which is why it's very important. Always know the rules, don't overstay. But again, if it is an overstay where it is completely unintentional, uh, and you have a reason, a good reason, go back to USCIS immediately, as quickly as possible, explain what has happened, and at least it is documented. And then USCIS will review cases on a case by case basis, and then decide what exactly they will do. But what I want to suggest is just to even avoid being in that situation, always know the rules, know how to look at your I-94. It is very simple. Know how to check your I-94, because people do have multiple I-94, CBP and USCIS issued. Understand the last action rule, and doing so, you don't even get into this kind of a bad situation.
Absolutely. Well, thank you so much, Chand, for that. And I wish Shravan had put in the questions earlier, but nevertheless, Shravan, what I can say is if you're still here, quickly tell us what your question is. Maybe we could pick up one or two. And otherwise, what I can suggest is watch this whole session. And I hope that, your questions would be clarified with these very important points and tips and information that we shared in today's session. Chand, I'm really grateful for you. You joined us here and, you know, greatly imparted so many important information that we are all taking back with us. So thank you so much for today's session. It was lovely having you.
Thank you, Nipasa. Thank you, everybody.
And that's it. I think keep track of all the updated laws and make sure of what your status is, when is your expiration date. Take care of each and everything because all things immigration are important so that you don't fall in trouble. And most importantly, don't forget to subscribe to our channel because we come up with the latest updates for you. And yes, thank you so much, everyone, for joining us. Don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out on YouTube, LinkedIn, Facebook, X, and on Instagram as well. And also, in case Shravan, you have your questions, why not contact Attorney Chand Parvathaneni directly? And yes, you can check him out on this link, which you can see on the screen. That's it for now. Thank you so much, everyone. This is Nipasa saying bye for now from Immigration Talk Show. But stay tuned on our channel.